Good evening, everyone. We are going to discuss to you the Module 5, Extinguishment of Obligations. Article 1231, obligations are extinguished, first, by payment or performance, second, by the loss of the thing due, third, by the condonation of remission of the debt, fourth, by the confusion or merger of the rights of the creditor and the debtor, fifth, by compensation, and lastly, by innovation. And we will discuss to you the first three parts of extinguishments of obligation. The first one is by payment or performance. Article 1232. So, ibig sabihin, it is not just about the money. It is not confined only to the delivery of money or payment, but also to the giving, doing, or not doing a certain act. And may nabanggit tayo na payment means not only the delivery of money, but also the performance, which is payment and performance are twin terms. Payment refers to the obligation to give, and performance refers to the obligation to do. Pero kailangan meron tayong pre-existing obligation. Kasi kung wala kang obligation, wala rin naman tayong babayaran. For example, ako ay may option na bumili ng isang kotse in 1 week. Kapag di pa ako nakapag-decide na bumili ng kotse in 1 week, then wala pa akong obligation. But once I buy the car, an obligation arises and now exists. And in order to extinguish the obligation, I need to pay the car. Article 1233. So this provision answers the question that when was debt or obligation considered paid? So, we have two requisites under 1233, and these are the integrity of the prestation and identity of the prestation. Integrity of the prestation, ibig sabihin nun, the prestation must be fulfilled completely o dapat completely delivered or rendered. So, pwedeng partial or irregular, so otherwise, hindi ma-extinguish ang obligation or performance. For example, I bound myself to pay Kyla at 10,000 pesos and I only pay her 9,000 pesos. That's why Kyla refused to accept the 9,000 pesos because the fulfillment is not complete. Identity of the prestation. The very prestation must be delivered or performed. Meaning, kung ano mismo ang napag-usapang gawin or ibigay, ayun mismo ang ibibigay or gagawin. Payment. Ang payment ay hindi lamang tungkol sa pagdi-deliver ng pera. Kung hindi, ito rin ay tungkol sa pagbibigay ng isang bagay at pagkakaroon at hindi pagkakaroon ng paggawa. Bukod pa rito, payment is one of the mode of extinguishment of an obligation. Kung ang payment ay ginawa bilang penalty para sa hindi pagkakomply ng obligation or obligation not to do, so iti considered natin yun bilang co-payment. And ayon sa batas, payment and performance are the same. And remember, a debt may only considered paid if it is paid in full. So kung binayaran mo lang siya ng partial and the creditor does not satisfy, so ang word payment can never be mode of extinguishment of an obligation kung hindi ito buong binayaran. Article 1235. So ito naman ay panibagong exception to the rule that payment should fully complete to extinguish the obligation. So despite in fully knowing that it is incomplete, something is irregular sa payment, but the creditor still accept it without expressing objection, then the obligation is fully deemed, fully complied with, and it is based on the principle of estoppel. You are now stopped to question kasi nung nagbayad, di ka naman nagreklamo, and you accept it without any objection or protest. It's as if you have waived your right. And always remember that obligee knows that performance is incomplete or irregular, and he or she must know it, and he accepts the performance without expressing any protest or objection. Article 1236. First paragraph. Kaninong payment basic creditor is bound to accept payment at kaninong hindi naman siya bound to accept payment. In other words, the creditor is bound to accept payment or performance by the following. First one is the debtor kasi siya yung umutang or have an obligation or to perform an obligation. Next is any person has interest in the obligation. For example, guarantor. Third is the creditor. The creditor is also bound to accept payment from a third person who has no interest in the obligation where there is stipulation that he can make payment. Second paragraph. The question is, what is the effect of payment of the third person? Kasi nga, wala siyang interest supposedly sa obligation, pero gusto niyang magbayad. So, anong epekto nito? Dito papasok ang effects of payment by a third person. First one is, if made with knowledge of the debtor. Pag yung payment ni third person was within debtor's knowledge and consent, si third person na nagbayad is entitled to demand from the debtor what he has paid, either pending reimbursement and subrogation. Subrogation means the payer steps into the shoes of the creditor. Second effect is, if made without the knowledge or against the will of the debtor. If he paid without the knowledge of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. So, meron lang siyang beneficial reimbursement. So, the third person can recover only payment to that extent that the debtor was benefited. In other words, the recovery is up to the extent or amount of the debt at the time of payment. For example, Alex owes Bella the amount of 10,000 pesos. Sandy is a stranger na nag-offer bayaran si Bella ng 10,000 and si Bella ay may kakayahan na i-accept or hindi accept ang nasabing bayad mula kay Sandy dahil in the first place, Sandy is not the real debtor nor he doesn't have interest to the obligation and wala ring nakalagay sa stipulation na pwede siyang magbayad in behalf of Alex. If inaccept ni Bella ang bayad mula kay Sandy, the two effect will rise depending on the situation. If walang knowledge si Alex na binayaran ni Sandy ang utang niya kay Bella, then Sandy may ask for reimbursement of the said payment. Pero kung nakapagbayad na si Alex ng 5,000, Sandy may only recover 5,000 since Alex benefited from the remaining balance that has been paid.
Article 1238. Payment made by a third person who does not intended to be reimbursed by the debtor is deemed to be a donation which requires the debtor consent. But the payment is in any case valid as a creditor who has accepted it. Nakalagay po ay deemed to be a donation. Bale, kapag po ang third person ay wala pong intensyon na magpa-reimburse, ang payment po ay magiging donation but kailangan po ng consent ng debtor. Dahil sa donation po, kailangan po ng acceptance ng donee, which is, ang donee po dito ay ang debtor. Pero nakalagay po dito sa last sentence, but the payment is in any case valid as a creditor who has accepted it. Bali, kapag po inaccept ng creditor ang payment ng third person kahit po na walang consent ng debtor, ay valid pa rin po ang magiging payment ng third person. For example, P1 owes P2 1 million pesos. P3 in behalf of P1 pays P2 1 million pesos against the consent of P1. Although P3 had previously told P1 that he or she has no intention to reimburse, P2 accepted the payment by P3 in behalf of P1. Yun. Valid pa rin po ang payment ni third person kasi po inaccept ni creditor ang payment kahit po walang consent ni debtor. Article 1241. Payment to person who is incapacitated to administer his property shall be valid if he has kept the thing delivered or insofar as the payment has been beneficial to him. Sa article naman pong ito, payment to person who is incapacitated to administer his property shall be valid only. Kasi nga po nakalagay, an incapacitated person has kept the thing delivered. Ang second naman po is yung insofar as the payment has been beneficial to him. For example nga po, si debtor po is magbabayad kay creditor ng 1 million pesos but si creditor naman po ay baliw na or wala po sa wisyo ang pag-iisip or nga po yung sinasabi nating insane. Ang tanong po, valid pa po ba yung payment ni debtor? Yes po, kasi ang sabi nga po sa 1241 ay incapacitated person has kept the thing delivered. Payment made to a third person shall be valid insofar as it has redounded to the benefit of the creditor. Such benefit the creditor need nor be proved in the following cases. Dito naman po sa second paragraph is also be valid insofar as it has redounded to the benefits to the creditor. Parehas lang po ng unang paragraph na incapacitated person. As a rule po, the payment is not resumed. Dapat po i-prove na dapat yung payment ay beneficiated to the creditor. Tapos ito naman pong second paragraph, nabigay po ng tatlong instances kung saan po ay hindi na kailangan na i-prove yung benefit. So, valid na po siya. Number 1, if after the payment, the third person acquires the creditor's rights. For example po, if meron pong impostor agent, pero doon po kayo nagbabayad, pero hindi po siya yung unauthorized agent na magre-receive po ng payment. Pero yung impostor po yung ay naging owner ng company na binabayaran nyo. Yun po, na-acquire po niya yung creditor's rights na sabi po din ay the third person acquires the creditor's right. Number 2, if the creditor ratifies the payment to the third person. Example po, yung collector po ng kuryente. So, unauthorized person po siya. Then, nagbayad po kayo. Then, after po nung tumawag po yung electric company na nagsabi po na okay na daw po yung bayad nyo na payments. O, okay po yun na ratifies po ng company yung payment nyo. Number 3, if by the creditor's conduct, the debtor has been led, so believe the third person had authority to receive the payment. For example po, yung collector po, naka-uniform po siya, binigyan po siya ng company ng uniform para po ma-lead tayo na may authority po siya to receive the payment. Kaya po, valid po yung payment natin kasi nga po, na-lead po tayo sa kanya kasi po naka-uniform siya.
Ayon naman sa Artikulo 1244, ang prestasyon mismo ang kailangang ibigay bilang kabayaran. Una, real obligation to deliver a specific thing. Pangalawa, personal obligation na to do or not to do. Halimbawa, si debtor hindi pwedeng purasahin or obligahin si creditor na tumanggap ng isang bagay na pareho ang value or mas mahal pa sa bagay na ipapalit niya bilang kabayaran. Ayon naman sa Artikulo 1245, the shown in payment is the conveyance of ownership of a thing as an accepted equivalent of performance. Halimbawa, ang ibibigay ni debtor ay property para mapalitan ang amount ng money na inutang niya. Ito yung obligation is monetary, pero ang ibabayad niya ay property. Halimbawa, may utang ako na 15 million dahil na-ospital ang isa sa miyembro ng aking pamilya. Ngunit wala akong pang-cash or wala akong enough na pera para makabuo ng 15 milyon. Naisipan kong ibigay ang isang bahay ko sa probinsya na nagkakahalagang 15 milyon bilang kabayaran sa aking inutang na 15 milyon. It's like, bibilhin ni creditor ang aking bahay at ito ay magsisilbing bayad sa aking utang. Ayon naman sa Artikulo 1248, palagi po nating tatandaan na ang kabayaran sa utang ay kinakailangan laging kompleto. Dito sa artikulong ito, i-discuss natin kung kailan nga ba allowed na magkaroon ng partial payment. Una, kapag may usapan. Pangalawa, kapag ang utang ay liquidated or unliquidated. Halimbawa, ako ay may utang na 10,000 kay Maria. Hindi pwedeng tanggapin ni Maria na 5,000 lang ang ibigay ko bilang partial payment at hindi ko pwedeng bayaran siya ng 5,000 para na lang kung may agreement. Pangalawa, kailangan kong bayaran si Jose ng 10,000 plus yung share niya sa company from a partnership business. However, hindi pa yun nakakompute at naiko-convert sa cash. So, si Jose ay pwede mag-demand sa akin na bayaran ko muna siya ng 10,000 since ito lang yung computed. Pangatlo, may utang ako kay Jose na 10,000 at ang nasa usapan namin ay ang 6,000 ay due date today at ang 4K ay pwedeng bukas na lang muna. Ayon naman sa Artikulo 1251, lugar kung saan obligado ka magbayad. Una, lugar na nabanggit sa isang agreement. Pangalawa, cash on delivery. Patatlo, walang lugar na nabanggit sa isang agreement na ikaw ay obligadong ibigay ang bayad sa mismong tahanan ng iyong pinagkakautangan.
Good day everyone, I am Sian Faith Ilagan and I am going to discuss the Article 1252 and Article 1255. First and foremost, before we proceed to Article 1252, let me just enumerate the special forms of payment. Accordingly, there are 4 special forms of payment. The first is the application of payment or the imputation of payment. Next is the cession of payment or the assignment. We also have datation in payment, then the tender of payment, and consignation. Basically, we are going to discuss the topic about 1, 2, and 4. Now, Article 1252. This talks about the application of payments. Application of payment is a designation of the debt to which should be applied when payment is made by a debtor who owes several debts in favor of the same creditor. It is important to know the rules and application of payment kasi otherwise hindi natin malalaman kung alin ba sa maraming utang ang na-extinguish. Take note, application of payments involves several debts. Marami, dalawa or mas marami pang utang at the same debtor and creditor. For example, umutang si X kay Y ng 5,000 pesos and it is due demandable on September 1, 2021. Pagtapos ng 2 linggo, lumapit ulit si X kay Y upang mangutang ulit ng 7,000 and promise to give it back on September 15, 2021. Then, X asks again for Y for another 5,000 which shall be due and demandable on September 30, 2021. Noong September 20, 2021, nagbayad si X kay Y ng 5,000 at yung ibinayad ni X kay Y ng 5,000 ay pwedeng maaring sa utang niya noong unang umutang siya ng 5,000 or nung last niyang hiniram na 5,000. Dito natin malalaman sa ang utang ba niya i-apply ang ibinayad ni X. Let me discuss the requisites of application of payments first. First, there must be one debtor and one creditor, which represents the X and Y in the given. X is the debtor and Y is the creditor. 2. There must be 2 or more debts. So sa mga example nga natin kanina, we have 3 debts. 3. The debts must be of the same kind. Yes, they are in the same kind although different yung maturity date. 4. All the debts must be due. 5. The payment is not be enough to extinguish all of the debts. 5,000 pesos lang yung binayad ni X, imbis na 17,000, so hindi enough to extinguish all the debts. Kulang ang ibinayad ni X, so paano ngayon i-apply yung payment ni X kay Y? Now let's go back to Article 1252. How application of payment is made. Ang sabi, he who has various debts of the same kind in favor of one and the same creditor may declare at the time of making the payment. To which of them the same must be applied. So meaning, ang taong maraming utang, which is the debtor makes the designation kung saang utang niya ibabayad ang pera niya. And note reads sa word na to, at the time of making the payment. So, application must be at the time when payment by the debtor is made. During such time, yung pagbabayad niya, hindi after. Pero paano if hindi ginawa ni debtor? Basta na lang siyang nagbayad without designating kung saang utang niya ibabayad. Nagbayad lang si X, hindi niya sinabi kung saan doon. Doon ba sa first, second, or third debt? Kapag ganun daw, ang sagot ay nasa paragraph 2. If the debtor accepts from a creditor a receipt in which an application of payment is made, the former cannot complain of the same unless there is cause for invalidating the contract. So, if hindi ginawa ni debtor, the creditor makes it out by stating receipts that he issues unless daw there is a cause of invalidating the contract. Kung hindi naman pumayag or walang consent ni debtor yung ginawang pag-a-apply ni creditor ng payment, or if the debtor's consent and accepting the receipt was to be shaded like kung may fraud or may violence, force, and intimidation. If may ganon, hindi valid yung ginawang application ni creditor. So, paano naman kung invalid yung application ng payment or neither the debtor nor the creditor makes the application? Or if the application is not valid? Ito na yung sinasabi na application of payment made by operation of law. Yung batas na yung ngayon titingnan natin kung saan that i-apply yung payment. So, another question. Once the application of payment is made, may it be revocable? Na instead of the first debt, i-apply ay sa second debt na lang. Biglang nagbago yung isip. So, general rule, hindi na pwede. Unless the parties agrees in other words, pwede basta both parties agrees. Payag si debtor at creditor. Pero take note, kahit pa nagkasundo si debtor at creditor sa revocation na ginawa nilang application of payment, it will still not be allowed if may third person na makaprejudice. So that's it. Let's go to Article 1255. Article 1255, Cession of Payment or Assignment Cession in assignment in favor of creditors is another special form of payment. It is the assignment or abandonment of all the properties of the debtor for the benefit of his creditors, in order that the latter may sell and the same and apply the proceeds thereof to satisfaction of their credits. So again, this is a process kung saan lahat ng properties sa debtor ay ina-transfer sa mga creditors para mga creditors may sell them. Yung kita sa pagbebenta ng mga properties ni debtor, yun yung ibabayad sa utang. So, ano bang requisites para dito? 1. There must be 2 or more creditors. 2. The debtor must be insolvent. So, either partially or completely, basta insolvent na siya kaya kukunin na nga lahat ng properties niya para ibenta as payment sa utang niya. 3. The assignment must involve all the properties of the debtor. Lahat ng property. Kasi naging insolvent na nga. 4. The cession must be accepted by the creditors. Siyempre, dahil hindi ito may impose sa mga unwilling na creditors. So, meaning, this provision talks about a voluntary or contractual assignment. Kasi actually, assignment is classified as legal assignment or from the word itself by law, by provisions of law or by operation of law. Yung assignment, then yung voluntary assignment, which is ito yun, kasi under Article 1255, so the provisions talk about voluntary assignment. Let's now distinguish dation and payment from cession and payment. Both are substitutes of forms of payment or performance. Now, ano yung pinagkaiba nilang dalawa? So, dation and payment, there is usually one creditor. Kapag naman cession and payment, dapat 2 or more creditors. Second, in nation payment, it does not presuppose the insolvency of the debtor or the situation of financial difficulties. Basta yung pambayad lang, yung binayad sa utang is yung property kung pumayag si creditor. Kaya ito ay governed by the law of sales. Pero dito sa cession and payment, dapat si debtor is insolvent or partially completely. Para maibenta, kunin lahat ng property niya at ibenta as pambayad din sa utang. Kailangan insolvent si debtor sa cession and payment. Now, in dation and payment, pag hindi ito ay nai-involve lahat ng property, kahit isang property lang, yung bahay niya or sasakyan. Pero kay cession and payment, it extends to all of the property of the debtor. Next, in nation and payment, si creditor becomes the owner of the thing given by the debtor. Kaya tinawag na governed by the law of sales, so magiging owner siya. Pero sa cession and payment, si creditors are merely assigned or only acquire the right to sell the thing and apply the proceeds to their credits, pro rata. Proportionally, yun sa lahat ng creditors. Lastly, dation is really an act of novation, while cession is not an act of novation. That is all about the Article 1252 and Article 1255. Thank you for listening.
Hello guys, my name is Mark Oliver KNM De Los Reyes and I'm going to report Section 2, Loss of the Thing Due. Section 2, Loss of the Thing Due. Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay. So, when by law or stipulation, the obligor is liable even for fortuitous events, the loss of the thing does not extinguish the obligation and he should be responsible for damages. The same rule applies when the nature of obligation requires the assumption of risk. So, when loss of the thing will extinguish the obligation to give? First, the obligation is to deliver a specific or determinate thing. Obligation is to give a determinate thing. Obligor has an added obligation to take care of a thing with the diligence of a good father of a family. Otherwise, he is negligent. Second, the loss of the thing occurs without the fault of the debtor. For example, is the thing is perishes, the things goes out of commerce, the things disappear in a way that its existence is unknown or cannot be recovered, and impossible because the thing is to be delivered belongs to others. And if the loss is without the debtor's fault, he has the burden to prove his innocence. And the third is, the debtor is not guilty of delay. And for example is, debtor cannot be delivered on a due date, and if after delay, the thing is lost to fortuitous event, debtor is liable. And the effect of fortuitous event is the fortuitous event is does not necessarily extinguish the obligation to deliver a determinate thing, and it shall be extinguished when the determinate thing shall be lost or destroyed without fault of the obligor or debtor. Article 1263, in an obligation to deliver a generic thing, the loss of destruction of anything of the same kind does not extinguish the obligation. So, example, Jesper promised to deliver 100 canvas of rice to Julian. The 100 canvas of rice which Jesper is intended to deliver were lost in a flood. So, Jesper is liable to Julian because his obligation is to deliver a generic thing and it can still be paid from other sources.
Section 3, Tender, Payment, and Consignations, Artikulong 1256, kung nagpapautang kung saan kabayaran ang ginagawa at tinatanggihan ng walang kadahilanan, natatanggay pa nito at nangungutang na maaaring pakawalan sa kanyang responsibilidad sa pamamagitan ng consignations ng mga bagay o kabuuan na dapat bayaran. Ang consignations ay maaari maglabas ng parehong epekto ng mga sumusunod na pangyayari. Kung kailangan na nagpapautang wala o hindi na makikita sa lugar na magbabayaran. Number 2, kung kailangan siya ay walang kakayahan na tumanggap ng bayad kapag dumating na ang takdang panahon na dapat nang bayaran. Number 3, kung kailangan walang dahilan, natanggihan niya na magbigay ng resibo. Number 4, kung kailangan dalawa o higit pang tao ang humahabol ng karapatan na kumalekta. Number 5, kung kailangan ang titulo o obligasyon ay nawala.
Article 1270. Condonation or remission is essentially gratuitous and requires acceptance by the obligor. It may be made expressly or impliedly. One and the other kind shall be subject to the rules which govern inefficacious donations. Express condonation shall furthermore comply with the forms of donation. First, what is condonation? Accordingly, it is defined as a gratuitous abandonment by the creditor of his right. It is actually a form of donation. Simple example, the girl owes the boy 1 million pesos payable on June 28, 2021. Then, comes June 28, 2021, sinabi ni boy kay girl na she don't need to pay the 1 million pesos. He's condoning it. Here, the obligation was extinguished through condonation or remission. Simple as that, an abandonment of the creditor's right in favor of the debtor. Now, here's the requisites of condonation or remission. First, it must be gratuitous. So, yung cost ng pag-condone ng credit o sa right ni creditor is no other than the liberality of the creditor. Dapat walang exchange or free of charge. Second requisite, it must be accepted by the obligor. So, halimbawang sa donation, mabibigay si donor, kailangan i-accept siya ni donee. This is expressly required ni Article 1270, meaning this is a bilateral act. Third requisite, the parties must have capacity. Of course, capacity is always necessary. It is somehow for the transactions to bind. Fourth requisite, it must be inefficacious. Sabi nga, no one can give more than what which she can give by will. So, hindi mo pwedeng ibigay lahat, dapat magtira ka syempre para sa sarili mo o pang tusto sa sarili mo. Fifth requisite, if made expressly, it must comply with forms of donation. Example is pag yung remission is ginawa sa last will and testament ng isang tao. Dapat yung last will din na yon is valid para maging valid yung condonation or remission. So, that's it. Moving on to Article 1272, whenever the private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily, unless the contrary is proved. So, Article 1272 tells us about the presumption of voluntary delivery. So, pag yung private document na nandun yung utang o ebidensya ng utang ay napunta o nakitang na kay debtor, merong presumption na voluntarily dineliver sa kanya, unless the contrary is proved. Dahil presumption nga lang naman, the creditor can always overcome such presumption. Pwede niyang i-prove na hindi niya binigay voluntarily kay debtor. Next is Article 1273. The renunciation of the principal debt shall extinguish the accessory obligations, but the waiver of the latter shall leave the former in force. Here, sabi is yung pag-accessory obligation yung renounce, siya yung kinondone o niremit. sabi it shall leave the former in force, meaning the principal obligation will still exist even without the accessory obligations. Last is Article 1274. It is presumed that the accessory obligation of the pledge has been remitted when the thing pledged after its delivery to the creditor is found in the possession of the debtor or of a third person who owns the thing. Pledge parang sangla. Magbibigay ka ng isang bagay o accessory as a security na babayadan mo yung inutang mo. So sabi, pag daw yung bagay na sinangla ni debtor kay creditor ay napasa kamay na ulit ni debtor o sa may-ari ng bagay na yon, there is a presumption na yung pledge has been remitted. For example, may utang si boy kay girl na 1 million pesos. Then, binigay niya yung watch niya kay girl na worth 1 million pesos din as a pledge. And later on, nakita na lang na kay boy na ulit yung watch. There is a presumption na niremit na ni girl yung accessory obligation na pledge. Note that under Article 1274, only the accessory obligation of pledge ang presumed remitted, hindi kasama yung principal obligation. So, the boy still needs to pay his debt of 1 million pesos, only that this time, wala nang security, wala nang pledge, purely loan na lang. That's all.